Good morning, sir. My name is Keith Wilson, counsel for the convoy organizers. I apologize for my voice. I'm recovering from a cold.
I have a bit of the same.
Thank you, sir. Sir, we're not in a position to proceed with cross at this time, and there's two reasons. One is the federal government has disclosed over a week ago an extensive volume of documents that are highly redacted. It is obvious from the face of the documents that they don't meet the criteria for lawful redactions. A motion was made last week for those redactions to be lifted. The submissions closed on Thursday evening. We still have no ruling. A number of days have passed. For the cross-examination and the discovery of truth process to be valid and effective, the parties require access to the documents. We don't have that. So we would appreciate some indication as to when the commission is actually going to rule on that and hopefully compel the proper disclosure of the records so that cross-examinations can be effective. I emphasize that these documents are not related to future witnesses, but present witnesses. So we're making the process inefficient with all due respect by not allowing the parties to have access to unredacted documents. Second reason we're not in a position to proceed with our cross-examination at this time with this witness is our lead counsel, Mr. Brendan Miller, who had prepared for the cross, as you know, sir, has been removed from the room by you when he was raising a motion to find a way around the absence of a ruling on the redactions. So we're just not in a position to proceed on cross, sir.
Okay, well, just on your first question, it is expected that the ruling will come out at during the lunch hour. There have been a fair amount of back and forth without going into detail. There's some, let's say, innovative type of issues that had to be dealt with. So that should come out at the lunchtime, which I'm happy to, I will do my utmost. It's going to come out, unfortunately, probably not on the record, the website, because it won't be translated, which is one of the issues we have to deal with. But we will, in light of what you say, we'll issue it in English only for the moment, and it will be posted when it's bilingual. But I understand that submission. So that should enable you, so we can put off the cross-examinations till after the lunchtime. In terms of the other problem, that's not something I can deal with. I'm trying to deal the best I can with the situation, and quite frankly, if the issue had been raised the way you have now, I would have given the answer I'm giving now. So what I propose then, since this witness will be here after lunch, we simply delay till after lunch. If you could endeavor, because I see you have, Mr. Will, you have a co-counsel, so can sort out how that can be done, that would be appreciated.
Thank you, sir.
Well, there you have it. That man was Keith Wilson, and in our pop-up studio in the belly of Ottawa is that same lawyer, Keith Wilson, who joins us now live. Keith, nice to see you. What happened at lunch? What did the judge rule on these sneaky redactions, these blacked out passages? What did the judge do?
Well, he went through each of the large bundles of documents and indicated whether or not he was going to order or require the federal government to lift some or all of the redactions. For the majority of them, he allowed the redactions to remain in place. But for some of them, he did rule that the redactions had to be lifted and that we were allowed to see what was behind the big black smudges. And so, as your reporters were witnessing in real time, while the cross-examinations are occurring on Minister Mendocino, we're simultaneously now going through and reviewing these documents, trying to assess what questions to ask. And I believe we received them after Brendan Miller ultimately did his cross-examination, so we had to figure out a way to get them in. And one of them was pretty spectacular that we read.
Oh, which one was that?
It was a note from that staffer that you discussed earlier, from him attending a cabinet meeting about whether or not they were going to invoke the Emergencies Act. And the note that they had blacked out was him indicating that CSIS advises that Section 2 is not met, and then there's plus Jody Thomas, being the National Security Advisor, being informed of that. So notes from a real-time meeting confirming that they received the cabinet a briefing that the legal requirement to lawfully invoke the Emergencies Act was not present, and the information was conveyed to Jody Thomas.
You know, I think we have a clip that touches on that. It's clip number 10. Jody Thomas, the National Security Advisor. Let's see if this is the clip that matches what you've just described. Clip number 10.
SSM.can.407721. We advise that the Commission Council should look at it as it is relevant and material to this witness. In particular, Jody Thomas, the National Security and Intelligence Advisor, states in that document that there is no national security threat pursuant to Section 2 of the CSIS Act. SSM.can.4077.
So did he answer that, or did he just sort of sit there when that was put to him?
Well, what we had to do at that time, because our opportunity to ask questions had passed, we took the position through our co-counsel, Bathsheba Vandenberg, who you hear speaking there, and we instructed her. We made the decision to keep Mr. Miller away from the microphone as much as we could, given the events of the day. And so Bath, who's a brand new lawyer, got thrown into the frying pan. She handled herself great. And we took the position that because Commission Counsel get the last chance, they ask questions at the start of a witness, and they ask questions at the end of a witness. So our view was that now that we know this document exists, as of a few minutes ago, Commission Counsel, who can still ask questions of Minister Mendocino, should be putting it to him. Initially, they said, oh, well, we'll just let Rouleau says, well, we'll just let it be in the record. No, you need to put it to the witness, and they eventually did.
Oh, they did?
So,
oh, that's good. And
yes.
and what was the answer?
I can't remember his answer, but, it's one of those things that doesn't matter.
And it's funny because on my show tonight, I go through some texts where Mendocino's own deputy minister isn't even bothering to show Mendocino some report. He's sharing it with everyone else in government, but not even his own boss. I think Mendocino's regarded as a bit of a joke, a real intellectual lightweight, and not a decision maker, even by the government of Canada. I think he looked like a fool, but Trudeau must be delighted with his duck speaking. Well done from the Trudeau point of view. What do you think?
Well, they're all doing it, and Blair did it yesterday, and we're going to see more of it in the coming days. But let's be clear about something, Ezra. I mean, there's interpretations of law that are difficult under statutes where there's these strange situations that maybe don't fit well. This is not one of them. The act is very straightforward. It says threats to national security is the trigger for a public order emergency. Okay? Threats to national security. It defines it as Section 2 of the CSIS Act, which has 4 things. You can have any combination of the 4, any one of the 4, and if you hit any one of them or any combination of them, then you meet the threshold. All of the evidence has been from all of the police officials, the government officials, that none of the 4 elements were present in the CSIS Act, including the most recently unredacted document from a few hours ago this afternoon, saying the elements in Section 2 aren't there. There's nothing else to look to. This is, there's times where lawyers can do a sleight of hand and twist and distort things. They're making this up out of whole cloth.
And do you think the judge knows it? Like, I know it, you know.
Absolutely.
The judge knows it?
Well, I'll tell you why. because one of the other lawyers yesterday walked Blair through each of the four elements and then proceeded and got Blair to confirm that none of the four elements were present for there to be a Section 2 threat to national security. And then the lawyer went to pursue a new line of questioning, ran out of time, and then asked for more time. And Rouleau said, "You're not going to get any more time. You wasted time by going through all four elements. We all know, and all the evidence has been that they weren't met." And, we all felt like closing our laptops and saying, well, I guess we can go home now. So it's
That's what they say in Latin,
like you say.
QED, that which was to be demonstrated. QED,
Yes.
there it is. It's right there.
Yes.
Let's pack it up. Now, by the way, our intrepid Olivia, I think she's found the clip we meant to find later of these questions that you guys smoked out being asked by commission staff. I think that's what we got here. Let's take a look. I haven't seen it, but Olivia said she thinks she might have found it. Let's just throw that clip up before we forget. Let's take a look.
What is the date of this note?
I'm afraid I don't know.
Well, look, leaving that aside, yes,
It
I was.
says it's before the speech Monday morning, which is
Okay.
the date that they announced the invocation. That might assist.
Okay. Yes, I was aware that CSIS had concluded that Section 2 under the CSIS Act was not met. I was aware of that fact.
Well, there
Thank you.
it is. Well, there it is right there. There it is. There it is. Like that's, he's making Section 2 of the CSIS Act. Yeah, that's the test, brother.
That's it.
I mean, for 1 minute, he speaks plainly to make the confession. There it is. We're done. We're literally done. There's nothing more. There's nothing more.